All right. Freedom now, guys. Freedom now. Welcome. Come on in. We're going to have a special time together. This is our holiday show. We have so much to talk about on the good news side of things. This is our good news immigration live show today. It's Christmas. We are obviously feeling the holiday spirit because we've decided that we're not going to let Christmas pass us by this year, guys, without the joy and the excitement that's in the air that always comes every year. And despite the challenges that we faced this past year in 2025, guys, we have so much to be thankful for. And so if you're feeling good today and you'd like to be part of this special holiday show, just come on in and say freedom now and bring your good energy. It's so great to see you guys. We have some good news stories to discuss today. And if you have any good news stories, go ahead and share your stories in the comment section. Only good news, okay? Share some good news with us and let's just get things livened up here on our show today. I'm LaToya McBean Pompy, an immigration lawyer in New York. We work with clients nationwide and across the globe at McBean Law, where we believe in freedom. And I see that Instagram is lit up. Thank you. Let's get TikTok all lit up, lit up. Come on, guys. Let's go with your freedom now, freedom now, freedom now. We work on complex cases, guys. It's always a challenge, right? We look at the cases knowing that, okay, it's a challenge, it's an uphill battle. And what can we do to help this person get through this difficulty? And so today you're going to hear some stories. From some of our clients, real people who face some serious, serious challenges with immigration and how we were able to work with them to help them overcome. If you feel like you need some encouragement today, this is the show for that purpose. We can be reached at 914-898-9488. Our phone lines are open from 8 a.m. to 8 p.m. Monday through Friday. We're going to obviously be closed on Christmas Day, but we'll be here on Christmas Eve and also the day after Christmas on the 26th. And you could also reach us this coming Saturday as well on the 27th from 9 a.m. until 6 p.m. The phone lines will be open to answer client calls as well as to book consultation. So come on in, guys, say hello. And if you have any good news stories, share your stories. Happy holidays, Merry Christmas. I see the holiday cheers coming in. Awesome. Good to see you, Kerwin. Thank you so much for being here and for all of you who are here with us today. So if you'd like to see the presentation, I'm going to share a special presentation. Jump over to YouTube, McBean Immigration TV, and you'll see the presentation with the rest of the folks who are watching today. Thank you so much for being here. Elizabeth is asking about our phone number again. Elizabeth, it's 914-898-9488, or you could also go to the bio page in our app on Instagram. Happy holidays. Happy holidays. Good to see you guys coming in. All right. So let's talk about some good news, right? Because we've had so much negativity this year. And guys, pat yourself on the back. You survived, right? We made it through. Yes, bad news continues to flow from Washington, but we made it through. We are here together. We're standing strong. We're together. There has been a lot of victory across the country this year, despite the bad things that we've seen as well. So let's get into some success stories, guys. And the first success story has to do with a client from Kenya. She came to the United States and encountered significant problems becoming a green card holder after a decade of denials and removal. She was in deportation proceedings. Why? For falsely claiming to be a U.S. citizen. According to USCIS, they wrongly said that she falsely claimed to be a U.S. citizen, and she gets her green card. She got her green card through the process that we worked with her on. A single check mark, guys, on an outdated I-9 employment form nearly destroyed our client's future in the United States. After entering the country legally from Kenya as an F1 student, she mistakenly selected a combined, if you remember, the old I-9 form had the combined U.S. citizen or national checkbox. And so she did that, and thinking that national referred to her foreign status, which it's an error. And USCIS later treated this as a false claim to U.S. citizenship, triggering years of denials, removal proceedings, and withdrawn petitions, despite a long-term marriage that she was in with a U.S. citizen, and she even had a child. They have a child together. When she came to McBean Law, we uncovered the original pre 2009 I-9 form, proved that it was ambiguous, and demonstrated that she never intended to claim citizenship. An argument so strong that an immigration judge also terminated her removal proceeding, her removal case. With that barrier removed, we successfully filed her adjustment of status case, and in September 2025, she was approved for her green card just days after her interview. Guys, there's a lot more to her story than this. We have it up on McBean Law's website, mcbeanlaw.com/success. You'll read more about the appeals that she had sought over the years that were denied. You'll learn about her I-130 cases that were denied, and the fact that her husband had to file a third I-130 petition. There's just so much to her history. And despite all of those challenges, she was able to get her green card. There are takeaways, okay, takeaways from this, but I think the biggest takeaway is never, ever, ever give up. Do not give up on your ambition to be lawful in the United States. Do not give up on your fight. Okay. But also, small mistakes on immigration or employment forms can have life-changing consequences. Allegations like false claim to U.S. citizenship depend heavily on your intent at the time and not just on a checkbox. And also, old and outdated forms can be misleading, making record review critical. These were the three big takeaways from this case that we thought that you need to understand. Don't ever give up, even if the government got it wrong. And it seemed like, although they got it wrong, they have a strong argument against you. Okay. Even if it appears that, wow, this wall, I cannot climb this wall, I cannot get over this wall, keep in mind that with strong help, okay, and a mind that is very critical on the attorney side, looking at your case can make all the difference in the world. Get your second opinions, get your third opinions. Sometimes I tell people who I meet with, I think you should get a few other opinions, okay? I'm sharing my opinion here. Here's how I think about it. But, fine, go seek out other opinions, because when it's all pulled together, you're able to, at that point, make understand it from all different angles. And so by the time she came to us, guys, she had been through attorneys in the past who weren't able to help her cross that finish line. And so we looked at everything, and we're so thankful that we were able to help her in this situation. If you like this story, type in freedom now, freedom now. Experience matters. Okay, it really, really matters. All right. And I think she had the consultation with me. And even during I remember this one, even during the consultation, I was thinking to myself, oh my God, how are we going to do this? This one is tough. This one is really hard. But let's go ahead and move forward and study this out and see if there's an argument that we could make for her. And we're so thankful it worked out for her. All right. So that's so amazing for her. Now let's get into the second story. And this story, guys, we shared a similar story yesterday in our newsletter. It's about a client who she's from Jamaica, and she she had some real problems, guys. She had some real problems, okay? I really encourage you to read the full story. I'm just going to give you a summary here. It was really tough. And this is an I-130, I-485, and an I-601 waiver approved after complex marriage and misrepresentation issues on her record. She came to the United States from Jamaica on her visitor visa, a B1, B2 visa, and she married a U.S. citizen, only to later discover that his prior marriage had never been legally dissolved, forcing her to withdraw her first adjustment of status case. After the issue was corrected and they remarried, a second obstacle surfaced: a prior visa application where an agent incorrectly listed her as being in a common law marriage created serious misrepresentation concerns. And the fact that the prior marriage was never noted on the previous application for the green card also added to the doubt that USCIS had about her credibility and about the truth of the matter. And so when they came to us, actually, we identified the need to file a waiver, the Form I-601, and build a powerful case proving extreme hardship to her U.S. citizen spouse, including the fact that he had prostate cancer, chronic medical conditions, and lack of ties to Jamaica. We filed a strong packet of the I-130, I-485, and I-601 waiver, prepared her thoroughly for her interview because we knew it was going to be tough. And in just 1 week after a challenging USCIS interview, all of the applications were approved, proving that even the most complex cases can succeed with the right legal strategy and persistence. Because again, guys, persistence was the key to her story. She did not give up, okay? And then there are some additional key takeaways I think that we could learn from her story. Number one is that past marital and visa mistakes can create serious immigration barriers. And how many of you out there know, and I know that you're out there because you meet with me and my colleagues, you know that what you've said on a visa application matters during your green card process. Okay, so for instance, if you had a visa case, a DS 160 tourist visa application that you filled out or an agent filled out claiming that you were married and you have children and that's not a fact. It's just not correct. And mistakes do happen. Sometimes these agents do mix your facts up with someone else's facts. And when that happens, it's very frustrating, I know, because it's very difficult to prove that, oh, you didn't really know. And you had no intention to misrepresent to the government. And the government is looking for that intentional misrepresentation. It has to be something that you had decided. You said, I am going to put this information on this application because I think this is the only way for me to get through. And if you had that intent, you intentionally misrepresented, and that is a problem. That is fraud, and it is a problem for immigration. However, our system has provided a way forward through a waiver process for you to bring that problem to immigration and say, here's what happened, and I'm sorry, and here's why I think you should forgive me, so to speak, of this misrepresentation. And I'm going to submit my waiver based on my spouse or my parent who is a U.S. citizen or a green card holder and the extreme hardship that that person is going to face if I'm deported or sent back home to my home country. So the government allows you to make that argument through the waiver, the I-601 waiver. And if you're successful with that argument, they will forgive you and approve your case. And that's what happened here. Other times, an agent just makes that error, and it was certainly not intentional, okay? And so it's hard to prove that. And we've been successful in some of our cases where the agent makes this error and you signed the form, okay? You signed it. And the government thinks that if you signed it, you knew what was on there. You knew, right? So how can you convince us now that you didn't know? no, because it's your signature that's on that application, not the agent's, or the preparer. And then furthermore, it gets even more complex if you indicated on that DS-160 visa application that you didn't even have a preparer. Okay, and now you're saying that it was a preparer? Guys, you've got to be careful with your arguments to the government. It's misrepresentation when you really try to go down those types of the argument that, oh, I didn't know and this and that. It's very difficult to convince them that, oh, you really didn't know. So if you're in a situation like this where you have an old visa application that has misrepresentation on it, certainly meet with an attorney and see how you could strategize your way out of it and file a waiver. Okay, because that is really the only way to then get your green card through adjustment of status. As you're coming in to today's live session, this is our special holiday show. You can say freedom now. You could also share a good news story from 2025. It doesn't even have to be immigration related. It could be something else. It could be another victory that you achieved this year. Let's just light up the comments section with just some good news, okay? Because people are reading your comments and they are looking for encouragement. So encourage someone today with something good that happened to you this year. Maybe you got married. Maybe you had a baby. Maybe you found a new job that you like, or maybe you found that a housing, I don't know, or maybe you passed the bar exam or something big like that as well. Share it, guys. It's all about the joy today. It's all about that. So let's get into the joy, the spirit of the season. Thank you for those of you who are sharing your good news, stories, and victory. Okay. Let's go, guys. Let's get into the next takeaway that I have here. Okay, so the next key takeaway from this waiver case is strong waiver cases can overcome misrepresentation issues. Okay, if it's a strong case, you could overcome. And even during these times where USCIS is doing a lot of things that we don't like and they're undermining the process, you can still overcome even with a strong waiver case. And yesterday's testimony that we shared with our I-601 that was approved in 3 months. It's a similar case like this. The background is slightly different, but it's an I-130, I-485, and an I-601 that was filed in September of this year, and it was approved this month, earlier this month, after we went on that interview with our clients. So it is possible to still get an I-601 waiver approved today, right? Careful legal strategy and preparation can lead to approval, even in complex cases. Now, third story. Now, this man, our client, uh, and it's so funny that I would even say this man because earlier I was speaking to a colleague and I said, we do not refer to our clients as woman or man. And here I go, this gentleman, our client became a lawful permanent resident after 20 years of denials and a removal order. Okay, a removal order. Some of you are in a very similar situation. You're carrying around an old removal order and you're, having some issues or challenges getting away from that removal order. So here's what happened to this client, and he's from Haiti. Okay, so this is really timely for him. For nearly 25 years, our client from Haiti lived under the weight of an unresolved let's see. Well, I'm looking at the math here, but it's 20 years. Our client from Haiti lived under the weight of an unresolved 2004 removal order after his asylum case was denied. He survived years of failed motions, denied appeals, and legal dead ends, guys, despite building a life here in the United States. You guys know that when you come to the United States and years pass, you've built your life here. You have your home, you have new children, you have a new spouse, you have everything here, right, in the United States. And it's very difficult to think about giving all of that up and leaving the country despite the bonus despite the incentives that the government has provided. It's hard. And so in this client's case, he had TPS, temporary protected status. He was working as a teacher and he married a US citizen and they were raising their child together. But the removal order continued to threaten everything he had built here in the United States. So when he came to us, we pulled his old records from USCIS and I think other places, other agencies, and including the immigration court system. And we reviewed his history and identified a strategy that we thought could work. And it was a motion to reopen and terminate his old removal case. And this was based on prosecutorial discretion, working with ICE at the time on this case. We presented the fact that he had been in the United States a long time, a long-term resident. His family ties were very strong. He was also involved in his community. Guys, these are lessons that you need to learn too for your case. He was very much involved in his community. He had strong moral character, and we got our prosecutorial discretion request approved, and the immigration court granted the motion last year, August, which ended proceedings for him after 2 decades. With the case terminated now in court, we filed his adjustment of status case, and in November, USCIS approved his green card. Now, what I think is really important to pause and say here about this type of fact pattern, guys, is he had the removal order, which stood in the way of him getting his green card approved from USCIS, the I-485. We had to terminate the removal case first and then approach USCIS. Now, why am I saying this? All of this right now. I'm saying this because we also had a very similar case recently in which things went in a different direction, although we ultimately got a victory for the client. But in the other case that we had recently, we got the case reopened and terminated in immigration. The removal order was reopened and terminated, and that was that. And then we presented the I-485 adjustment of status case to USCIS, and this is a marriage case, okay? And this is in Arizona. And everything, this client also had been here for many years, strong community ties, like just, just a wonderful history, a wonderful person. And they go in for the USCIS interview, and there was no interview. It was all prearranged for this person to be arrested at his interview. This was a couple of months ago, to be arrested at his interview. He has no criminal record. There was no issues. His removal order had been terminated, and we go to the USCIS interview in Arizona, and they tell us, oh, he has a removal order. And we said, what removal order? Oh, the judge never signed off on his removal order. Well, we said we didn't need the judge. We didn't, the BIA, right? They came up with some absurd argument related to the fact that the immigration judge never signed off. And we said, well, there is no need for the judge to sign off because, first of all, it went to ICE first, they approved it, and then it went to the BIA, which had jurisdiction over this particular case. And then they didn't know what to do with those facts, and they said, well, we've got to take him in anyway. So they unlawfully detained him. And then we got to work immediately right after that, and we were able to get him out with bond. He got a really generous $1,500 bond to be released. So he's back with his family now. So as you can see, things sometimes go in the opposite direction. And when they do go in the opposite direction, you have to have counsel ready who knows how to get your loved one out of removal in the event that USCIS pulls something like this and tries to put someone back into the removal system who had already been through the removal system and should be in the clear right now to just finish up at the tail end and get the green card. So that's what USCIS did in that case. But in this particular case, guys, our client he got his approval. He got his approval of his green card. Now, just a few takeaways from this story. Old removal orders and past denials do not always mean your case is hopeless. Okay? Just because, again, this is a run-in theme today. Just because you've been denied in the past doesn't mean that you're going to be denied again. Okay? But if you have a removal order, you have to strategize carefully with your immigration lawyer before you approach USCIS, because it is a risky environment today. So you've got to really know what you're doing. Number two, a careful, full review of your immigration history can uncover options like prosecutorial discretion and some other options. And lastly, you're going to hear this again, experienced legal strategy can turn decades of uncertainty into a green card, all right, into permanent legal status. And then the last story that I want to share with you guys, it's about a bond being granted to another client who was detained while he was trying to leave America, guys. Okay, he was just trying to get out of here, trying to leave, and he got caught off guard, really, because he was on his way out, and there was no suspicion of anything. But here's how the story goes, and this was very recent. This was from just a couple of months ago. For our client from Cameroon, a routine stop during travel quickly became a terrifying detention nightmare. After entering the United States lawfully as an F1 student, on that student visa, he was studying nursing. And he was later granted TPS for Cameroonians, and he was suddenly arrested by Border Patrol guys, and he was transferred between jails in upstate New York and placed in ICE detention, all without a criminal record or any prior arrest. I mean, this is just he was just a good kid, really, and a smart guy, and never gotten into trouble at all. And he was leaving because he was frustrated because he lost his TPS, his EAD work permit, lost his job consequently, and he was frustrated and thinking, if I could just leave, things would be better for me. But be careful with how you depart, because how you depart can be a problem, as you'll see. With civil conflict in Cameroon, making his return to Cameroon would be dangerous because of because of the civil conflict there against Anglophones. So his family turned to us. I spoke with the relative actually in a consultation, and we immediately got to work and intervened. We started communicating with ICE right away because that's really what's needed. We filed an urgent motion for bond and custody redetermination based on his clean record, his community ties, and his credible fear of being persecuted if he has to leave the U.S. Well, to go back, if they deport him to that country, he was actually on his way up north. And so going back to Cameroon was completely out of the question in light of what's going on there and his fear of being persecuted if he were to return to Cameroon. At his November 2025 bond hearing, the immigration judge granted release, allowing him to reunite with his family and pursue his asylum case from freedom, proving that swift legal action and strong advocacy can mean the difference between prolonged detention and safety. All right. And some key takeaways from his case: immigration detention can happen suddenly, even without a criminal record. All right, keep that in mind, even without a criminal record. Quick legal action and strong bond advocacy can secure your release from detention, and a credible fear, clean history, and humanitarian factors all working together can make a good, powerful bond case. Friends, we have a lot more success stories on our website. Go to mcbeanlaw.com/success, where you will see those success stories. And also, it's not visible here. We have another page on our website, mcbeanlaw.com, that will give you some video testimonials as well. We're going to link to it below because there it is, mcbeanlaw.com/success Success dash stories. That's where you're going to find the videos for those of you who don't like to read. Okay. All right, guys. So amazing. There's so many more. And I've been sharing also additional stories on social media. We publish 52 success stories each year. And at the end of each year, we try to break them down, some of them down, some of the top ones via video for you. So go to Instagram at McBean Immigration Law, or even Facebook. Those two in particular have all of those video success stories. All right, guys, thank you so much for being patient and listening to all of these good news stories. I know that you have a lot of other concerns on your mind. Okay, I'm gonna just spend maybe about 5 to 10 minutes to answer some of the other questions that you guys have before we go today. Um, this is the holiday week for us at McBean Law. We will not be here on Christmas Day, but we will be here every other day, every day this week except Christmas Day. So you could reach out to us at 914-898-9488 or go to mcbeanlaw.com. Let's see if I could go through just a few of your comments and questions. Mike says, I just like to watch your show and I trust you. Keep up the good work. Happy holidays. Thank you very much, Mike. Thank you for being here. Let's see. Someone said, Bernice says, freedom now. I've been married for 3 years and we laugh about something daily, even though we are living in different countries at this time. You know what? That's great. That's great that you're communicating with your spouse, and you guys are sharing some joy despite the challenges and the distance. Um, I'm from Haiti. I have a green card. Can I travel without problems? Green card holders are not subject to the ban, okay? It doesn't matter where you're going. You're not subject to you're not subject to the current full entry ban if you're a green card holder. Freedom now, guys. Freedom Now, $3,000 after you return to your country. Yes, that is in the news today. That is in the news today. That's DHS, in a desperate attempt, has asked for, it is publishing a bonus of $3,000 for individuals to leave the United States. You could get more information about that on their website, and see how to do that if that's what you're interested in doing. Thank you. But certainly before you leave America, consult with a lawyer about how you could possibly return to the United States if you choose to self-deport. All right. Thank you, guys. Um, all right. Here's a good question. Let's see if I could just shift this up here. Okay. I'm a mother of 7 children who just got her green card approved last year, and I've been in the United States for a year now. Is it still possible for me to apply for my children using the form I-130? Absolutely. Get them in line. Get it going. Absolutely. Green card holder parents can petition for their children. Okay, get it going. Um, if you're a U.S. citizen, can you live outside of the U.S.? U.S. citizens do not have any restrictions on them with regard to how long you could be outside of the U.S. for. You will have tax obligations still, however. So speak with your accountant about how you're going to manage that if you decide to move outside of the United States as a U.S. citizen. Okay, let's go down a little bit. Okay, let's see. Any news about the family reunification? Jean Paul is asking. So, Jean Paul, unfortunately, the government has terminated that parole program, and but for some people who are immediate relatives of a U.S. citizen, or even others whose priority date is current, if you have an adjustment of status application currently pending with USCIS, you do not need to leave the United States. You could wait until your green card application is approved before leaving. Thank you, guys. I hope these stories encouraged you today to see that immigration is a process. You have to be persistent, and you have to have a good legal strategy in order to get through. Um, Miss McBean, how soon do I have to contact you when my green card removal is a concern? Is a concern. Have you already filed the I-751 petition? Remember, they are given these long, lengthy 4-year extensions. And so we've seen approvals come in at the 6-month mark, 8-month mark, and then for others longer than a year, more than a year, it's pending. If you've already filed a case and things have changed in your marriage, now is a good time to consult with a lawyer about what those changes are and what it means for your case. Do not sit and wait on it too long. If you're separated from your spouse and you guys had done a joint filing, okay? All right. Freedom now, guys. All right. Can I apply for cancellation of removal before TPS ends for Haiti? So you could do that if you're in immigration court and certain facts, time, it's a timing issue, obviously, but you must firstly be in immigration court in proceedings right now before an immigration judge in order to apply for cancellation of removal for the 10-year green card through the judge. TPS for Haiti it looks very strong, a strong likelihood that it's going to end on February 3rd, I think. And you've got to be in court, okay, in order for that to work out for you. Freedom now. All right, let's see. Guys, again, we are reachable to have a one-on-one with you at 914-898-9488. That's the best way of reaching us. What happened to the application that I've already put in for my mom in Nigeria? And I'm a US citizen. So the latest news that I shared on Saturday live is that CBS News is reporting that the 20 additional travel ban countries, including those that made a full entry ban list and then those also on the partial list like Nigeria, that USCIS is holding on to those applications and have paused them as well. Now, I have not seen this morning any announcement from USCIS indicating in a very official way that that's what's going on, but a source from CBS News, from USCIS spoke with CBS News. A source from USCIS spoke with CBS News to let them know that this is what's going on. We're not processing those applications. So as I said on Saturday, you guys can sue the government, and we're taking it on a case-by-case basis as well, because your case should move forward. They have no real justification to pause your cases, guys, because the travel ban is resting on a law that is based on entry into the United States. And so there's no reason that your applications currently at USCIS should be unfairly held up. So you have the right to file a mandamus to get your case moving, okay? There might be an injunction on this. I'm hoping that there will be an injunction very soon. Immigration wants me to pay a large sum for staying in the United States. Do I have to pay it or talk to my lawyer? So Thomas, if you probably I'm sure you have a final order of removal, because those are the individuals who are getting the large fine from DHS. Take it very seriously. You could consult with us about it if you'd like to. We've been working on these cases. You have to immediately get to work on this because they are going after folks' paycheck. Okay, they're going after the paycheck through garnishment, and the government does not have to go through any lengthy court process to begin garnishment against an individual. They can bypass, and they have been bypassing anything official, and they're going right to your employer for some money. So take it very seriously. Consult one-on-one with an attorney so that we could advise you about what your rights are. But absolutely, you have an obligation. You might have an obligation. It just depends on the facts. Thank you. Thank you. Can I travel internationally with my green card? Yes, you can. But if you have a criminal record, I would stay away from travel at this time. Okay. Thank you guys for being here. This is our holiday show. I shared a lot of four great stories earlier. Go back and watch the replay on McBean Immigration TV on YouTube. I'm now doing some Q&As. Thank you so much. I'm waiting for my green card renewal. I'm from Guyana. I don't know why it's taking so long. Well, one of the things that what you can do, certainly you have your receipt notice showing that your I-90 is in process. You could also make an info pass appointment and go get a stamp in your passport to show proof to an employer or whatever you're going to need it for, that you're lawful here. Okay. Freedom Now. Thank you, guys. If you have any good news from 2025, guys, share it in the comments section, okay, so that others can be encouraged. This is a good news show today. Okay, I answered a question very similar earlier. Can a child still file adjustment of status for parents from a partial ban country? Yes, you could still put in your application, of course. You can do that. The question is whether what USCIS will do with it, right? But you should file. Okay, thank you. Do you accept DACA and DACA plus advanced parole cases? Yes, we do. Yes, we do. Let's go up a little bit here. I'm sorry about the sound. There's something going on out there. We're going to be ending momentarily anyway. It's probably better for you to watch on McBean Immigration TV. Okay, let's see. Let's go up a little bit. Um, Someone who had a fraud case. Let's see something here. He filed a waiver and it was approved. Can he now apply for citizenship? Yes, but you can have a lawyer take a look at what those issues are that he was able to overcome in the past. The USCIS is a different agency now. They're very much on the law enforcement side of things, so you still have to approach them very cautiously if you have a serious record, including a record where there's fraud on your record. Okay. Thank you. What is the good news? I just joined. Watch the replay. Watch the replay. Thank you, guys. I see all of the thank yous. Thank you. We're going to end momentarily. Let's go up here. Okay, super chat question says, I'm from Haiti and I found an employer who can sponsor me as I am a nurse. Okay, great. Can they still file the I-130 and wait until the ban is lifted to file the I-45? I have TPS and an asylum case. Okay, so the employer would be filing the Form I-140 employer petition. Firstly, they would work on a labor certification for you, which is possible it could be approved. Um, it's the to do adjustment of status though would be a little tricky maybe for you. Why? Because the government wants to ensure that you had continuously maintained a lawful status. And so that's what they're going to be looking for at the time that they approve an I-45 for you. What I'm thinking is going to happen with Haitians in February once TPS ends is that this government is going to try to, they're going to shift people into the removal system. Okay. Um, and so if that were to happen in your case, and yet your employer is going through this process, certain parts of your employer process can work out and you can be approved. Even the I-140 can be approved, of course. But to adjust your status, that's when we're going to have to really wrap our heads around whether you're eligible to adjust your status at that time. Okay? Thank you. Um, let's see. Let's go over here. Freedom Now. What happens to someone who has a green card and has filed for citizenship but is Nigerian? From what I'm hearing, and I can't verify what some of these stories are, but what I've been hearing is that the naturalization interviews have been canceled, okay, for people who are from the partial as well as the full ban list. Although USCIS, as I've said earlier, has not come out with an official statement saying that they've paused these applications. CBS News is reporting that their source says that they have in fact paused these applications and have not been moving forward with these applications, and oath ceremonies are being canceled from what I understand. Okay, but again, guys, you could fight this. The key today is fight, fight, fight. Don't sit on your immigration problem. There's a way forward, okay? And if there's anything 2025 taught all of us is that you've got to be persistent. As I'm trying to be persistent through this noise next to me here, our office is right by a firehouse. Stay on your case, guys. Don't lose hope. Don't lose heart. Work with the right attorney. Be careful who you work with. And work with someone who can ask critical questions about your background. Stay encouraged. 2025 was hard. 2026, I know that this administration is going to throw some things at us in 2026 as well, but we can get through it together as a family. Hang in there, hang in there, hang in there, and you will overcome. Again, guys, we're reachable at McBean Law at 914-898-9488. And to see the success stories that I shared today and many more, just go to mcbeanlaw.com/success and just encourage yourself. Guys, Merry Christmas, and follow me on social media because I'll be really active during the holiday season on social media. Follow me on Facebook and on TikTok and certainly on Instagram. Follow me there where if news happens, of course, I'll break it to you as well. I'm still on the job, but I'll be taking a little break as well, like most of you. My God, we made it. We made it to the end of the year, and I'm so thankful for that. Thank you so much for being here, guys. And I'll be back before you. McBean Immigration TV, actually, my next show. Let's do this. Let me just pull up this calendar here just to get it right. Okay. My next Monday live will be January 5th. Okay. My next Monday Freedom Now show will be January 5th, 2026. Okay. I will not be live next Monday, the 29th. The 5th of January is when I will be back before you, and we'll have our Q&As and some other news, immigration news to cover at that time. Guys, thanks so much. I really appreciate you, and I will see you in the next one. Bye-bye.